Is this visible now?
Yes, yes.
Okay, perfect. So as I was saying, we're a full service firm. We become the startup's first legal counsels. We regularly advise startups on investment transactions, product compliance, data privacy laws, effectively whatever they need. And we have quite a bit of experience in this space. I have personally done approximately 12 or 13 deals over the last 2 years. Some of my key highlights include advising Google Capital on their Series C investment into Dunzo, advising One Crowd on their investment into Mojo, a few angel investors into investments such as Clinic Healthcare, and exit from Chios, investment into Players Bot. These are just a few of the deals that I've worked on in the last 2 years. And while we obviously do transactions, we also do a lot of tech-focused work, including advice on products. Whether the product that the startup is coming up with, regardless of sector, if it's fintech, clean tech, insurance tech, agri-tech, whether or not they're compliant with both legal, the legal requirements for privacy, and also for whatever other requirements are there to make sure that the product itself is compliant before we go to market. We become the first outside counsels. We effectively not just advise you on issues that you come to us with, but also try and become partners in growth with you. So we will connect you with investors, we will connect you with mentors. If you feel that you can perhaps benefit from specific advice from an industry leader, we'll help you make connects there. We'll provide you relevant connects with investment bankers if you think that's the way to go to approach investors. We're a very new age firm. We provide a lot of services that traditional firms don't. Having said that, let's start the presentation. Just before that, what I'd like to know is, how would you like this session to be? Do you want it to be a very in-depth conversation about the legalities of different forms of compensation, or do you want me to just introduce the different forms of compensation and then tell you the pros and cons, and then we can have a session on whatever, have a question answer session on whatever you want?
So I think, Akshit, we can start with a brief introduction, and then, basis the questions that the audience come up with, we can go into depths if needed. Whatever works for you, whichever way you think is best.
Got it. Perfect. So let's begin. The first is, basics of equity compensation. Why is equity compensation required for startups, right? Obviously, startups, being early stage, ventures, don't have the liquidity and the cash to pay their advisors, their key employees, their tech leads, their founders, and there are times that you need to show a greater upside than you can currently give to a person right now to attract them and to retain that talent, right? Now, what an equity compensation does is that if it's effectively an alternative compensation structure. It gets people to buy into the idea when they think that, okay, their reward is directly linked to the growth of the company itself. They're that much more likely to sort of put in that much more effort. They're more likely to allow you to tell them exactly what you need, and to perform that a lot better than they usually would when they're just getting secure salaries and don't have to put in that extra effort, right? Now the next thing is, who do we really use? Who do we give this equity to? The equity, usually there are four, we can put it into four buckets. The first is key employees, early stage employees, so a tech lead, your CXOs, your product managers, your CMOs, etc. People who are just joining as you're starting out, people whose advice you really need to get to market effectively. The second is, tech leads. The reason I've mentioned this separately is because sometimes tech leads are not really considered employees. They may be outside partners who are looking to develop the entire tech for you, but they'll want some amount of compensation in cash and some in equity. The next is incoming founders. This we usually see within the first 6 to 12 months of the startup's existence. You'll start out with an idea with 2 or 3 founders. You'll have a lot of discussions. Then you'll realize that you may need the expertise of somebody else on a full-time basis, and who can bring a lot of, let's say, relevant connects, or industry-specific expertise, etc. And then you need to compensate them, right? So that is also something that you do this. And the final is obviously advisors, right? Anybody from industry leaders to mentors, etc. They will not advise you for free. It's very common to say that nothing in life comes free. The same goes for really good advice. They will always want specific equity compensation, specific upsides, to why they're providing you advice, how to grow yourselves, how to scale, and what will they really get out of it. So these are the four buckets that we can divide this into. The next is the how. So there are effectively um, 6 or 7 ways that you can do it. I've covered 6 ways here. The first is employee stock option plans. It's the most common, most universally known. I don't really think it requires an introduction for anybody. The second is very similar to an employee stock option. It's called a sweat equity share. That is also fairly commonly used in India. The next is a very, very simple transfer from existing founders. And for the purpose of this presentation, I am not really going to go into that much detail about transfer from existing founders because it's very, very plain vanilla. And at one time I'll get to why exactly it's not the most advisable structure. Then another is shares issued for consideration other than cash. That is, when people are giving you specific services, such as, technology assistance or go-to-market assistance or marketing, etc. You can issue them shares without them having to give you any money. The next is share warrants. A warrant is effectively just a right in the company to acquire shares at a later date, whether by subscription or by purchase from the company, or for other founders, etc. The final is a stock appreciation right. It's very commonly known as a phantom stock option plan. These are We are seeing a high number of startups sort of trying to do this now because of the non-dilutive nature of the right itself. This doesn't require any equity dilution on part of the founders or the investors, and therefore they're very happy to sort of go ahead and do this. Now let's go to the first part, which is employee stock option plans, right? So these are, as I said, the most commonly used structures till now in India. They obviously have a complete legal standing. The, section 62(1)(b) of the Companies Act covers this. However, there are a few features that you need to know, to effectively sort of utilize these. The first is ESOPs can only be given to permanent employees, which is employees which have been working for you either in India or outside India, or to directors, provided that these directors are not independent directors. They cannot be given to promoters or people who are part of the promoter group. Now, the definition of promoter group is anybody who, with their relatives, holds at least 10% of the shares of the company. Now, while this restriction is generally there, with regards to the promoters not being given ESOPs, this restriction has been relaxed for those startups which have been registered with the DPIIT. There are multiple benefits that you get from there. This is one of them. For the first 10 years, a registered startup can give ESOPs to a director or to a founder who holds more than 10% shares as well. Now, another thing is that there has to be a minimum 1-year cliff between the date of grant and the vesting of the shares. So let's say you formulate an ESOP policy today, you have to make sure that the vesting period is at least 1 year, and that's that before 1 year, no part of the option can be exercised by the employees. Then let's get to the benefits, right? Why do you really want to go for an ESOP plan? Obviously, these they are highly flexible. They can be conditional depending upon the tenure, the length during which the employee has been associated with the company. They can be linked to performance. They obviously allow incentivization of the employees to not quit, giving you loyalty, making sure that you can get the most out of the startups that are working, the employees that are working for you. They're very easy to implement because they are universally well known. They are there's no legal hurdle there specifically. There's no gray area in implementing an ESOP plan. And it's a fairly common sort of structure. There are 2 or 3 different ways to do it. One is administration by the company or the board themselves. One is by an ESOP trust. I'm not going to go into too many details, but if you have any questions, please feel free, and I will answer them at the end of the session. Then obviously, what are the disadvantages, right? As I said, they can only be given to employees and directors who are not independent directors. So it can't be given to your consultants like a tech lead. It can't be given to your advisors, all of whom want at least a little bit of a piece of the pie to make sure that their services are worth something to them at the end of the day. The second is tax incidence. ESOPs are taxed twice. One is at the time of exercise of the ESOP itself. So when the employee says, okay, fine, my shares are vested, let me pay you the agreed upon price, and you can grant those shares to me. At that time, the difference between the fair value of the shares and the price at which the shares are being allotted to the employees are taxable. So that can be quite a bit, depending on the valuation of your company now, right? Let's say the pre-agreed price was 100 rupees per share, and now the valuation of the company is such that it is 10,000 rupees per share at fair market value. Then in that case, 9,990 rupees will be the notional income which has to be taxed, and for which tax according to the tax rate has to be given by the employee at this time. The next point of tax is at the time of sale. Again, depending on how long the employees hold the shares, they will have to pay tax upon the sale income that they get from it. So it's taxed twice. This is one of the biggest disadvantages, and why we are seeing a move away from ESOPs now. Then the next is there is no easy exit option for the employees. The sale of shares through granted through options is highly regulated. You need to do price discovery, you need to get a valuation report, you need to make sure that all the other investors give their consent to making sure that the employees can sell their shares, etc. So these are, there's not an easy exit for the employees. So while they may have something on paper which is beneficial to them, they may not be able to realize that value when they really need the liquidity. Then the last is a cash outflow for the employees, right? Now this cash outflow is twofold. One, when they're exercising the option to get shares, they are paying the certain pre-agreed value, which is usually the nominal value, and let's say 10 rupees per share or 100 rupees per share, whatever the nominal value of the share of the company is. The second is, as I said, the tax. At the time when they're getting the shares, they have to pay income tax on that notional income, the difference between the fair value and the exercise value of the shares. And therefore they have to give out tax two times, one at the time of exercise and one at the end of the year, in the year of exercise, when they're paying the income tax. So this is the reason why a lot of people are not happy with ESOPs now. Then let's move to how exactly an ESOP plan works and what the procedure is. So it has four things. Effectively, it has four steps. The first is you grant an ESOP, or you formulate an ESOP policy, you get all the approvals, etc. in place. Then you grant different ESOPs depending on the roles of the employees to different employees. There can be conditions attached depending on length of employment, performance conditions, key performance indices, whatever the company is comfortable with. Then over a period of time, the shares will vest. It can be vesting at one time, after 1 year, the entire thing can vest, or you can say that 25% of the ESOPs will vest now, 25% in third year, 25% in the fourth year, and 25% thereafter. It really depends on the structure that the company wants to do. Once the ESOPs are vested, the employee can then pay the exercise price, which is the price which has been pre-agreed between the company and the employee in the ESOP policy, and then acquire the shares after paying this exercise price by the employee to the company. Then obviously in return on the exercise price, the company will allot the shares to the employee. And finally, and you don't really know when this is going to happen or when you can do it, the ESOPs the shares which are being granted in lieu of the ESOPs can then be sold to specific investors, etc., subject to the conditions mentioned in the shareholders agreement. Now, because of the nature of investment transactions, it's very likely that only somebody in a later round might acquire your shares. An investor coming in might acquire your shares. A key example of that recently happening is UrbanClap has recently implemented two buyback schemes where they've taken the shares back from the employees and given them money in return. But you have to look at how mature the company is, right? Like, while UrbanClap was only incorporated 5 or 6 years ago, at the same time they've reached a very high valuation, and that's why they can afford to do it. So the liquidity has always been in question for ESOPs, and therefore we usually don't advise people to go for ESOPs because of the liquidity factor, as well as on the double tax incidence on employees. Now, coming to the next structure, which is a sweat equity plan, right? A sweat equity is nothing but shares issued to employees or directors. This also includes independent directors for the services that they've given. So the consideration other than cash can be them developing their IP for you, them developing, them giving you some know-how, some marketing knowledge, any value addition really. The law doesn't specifically state what value addition it needs to be. It can be up to a 50% of the total share capital of the company. This is only for DPIIT registered startups. In the event your startup is not registered with the DPIIT, then it can be up to 25% of the total share capital of the company for the first 10 years. The benefits of a sweat equity over an ESOP is, as the same as ESOPs, they can be conditional. They can allow you to give the shares to incoming founders or incoming tech leads on a full-time basis, etc. Only after they've completed their services. You can see the value addition that they brought, and then you can grant the services. Then the next is there is no cash payout by the beneficiaries here. Right? If you look at ESOPs, depending upon the exercise price, it can be a high cash payment for the for the employees or the directors to whom these ESOPs are given. That is not the case in sweat equity plans. However, the tax incidence will remain the same. There will be tax on the difference at which the price is allotted, and the difference, and as well as the sale of the shares later on. The disadvantages here are bigger. Obviously, once again, they cannot be given to any advisors or outside consultants. The second is there is an actual equity dilution, same as ESOPs. You will see the ESOP, your founder pool and the investor pool decreasing. And the final is a 3-year lock-in period from the date of allotment. So now what happens is, let's say your agreement says that you'll provide XYZ services within 1 year. Once that's been done, there is you will allot these shares to the employee. Then there is a 3-year lock-in, which reduces again the liquidity that an employee or a director can really gain out of these sweat equity plans. Therefore, while ESOPs are still being done quite a bit, sweat equity plans are not being done because it requires multiple other compliances also, such as a valuation report for the shares, then also for the services which have been rendered, etc. So that these are the reasons that we're not really seeing a high adoption of sweat equity plans as a way of equity compensation. Then the next one is shares for consideration other than cash. As you can see, it's a serviceable option, but it's not really something that we see. While it is being done quite a bit, there are disadvantages to it in terms of the compliance is required. So it's a cost for the company while doing this. Now, what is a share issued for consideration other than cash, right? They are very similar to sweat equity in the sense that they are shares issued for services rendered to the company. However, unlike sweat equity plans, they can be given to anybody. They can be given to consultants, advisors, directors holding more than 10%, promoters, outside technology needs. Basically, if you want to reward somebody for their assistance to the startup, you can do it via this option. Now, the problem with this option, another feature. Sorry, the problem with this option is the fact that there is obviously equity dilution. And as I said, there are high compliances required with this, right? So you'll require 2 valuation reports. A valuation report will cost the company money, and it is very hard where the services provided are very hard to value, right? Let's say I'm providing you general strategic support, right? How do you value? How do you really value the amount of work that I've done for you or the amount of value that I've provided? That's the first part. And the second part is where the valuation of the company itself has increased manifold, right? The promised reward to the advisors or consultants, etc., may not be given. Let's say your company is valued at $10 million now, and it's the contract was for 1% or 0.75% of the entire share capital of the company. At that time, $100,000 or $75,000 invoice will have to be raised by these advisors or by these directors or consultants, etc. And then the company will allot these shares to them. So there are these disadvantages to it. Obviously, the benefit is that they can be they're completely conditional and performance linked, depending on whatever the contract says between the company and the advisors or consultants, etc. And Second is that there's no cash payout by the beneficiaries. This is the same as I said, it's effectively a sweat equity plan for outside people, so consultants, advisors, promoters holding more than 10%, etc. I'll stop here for a second because the next two are slightly more complicated and less common. So I'll explain them in detail. Are there any questions till now, or would you like me to explain something a little more?
So there are quite a few questions in the chat. Do you want me to read them out right now, or should we do it? Should we address them at the end?
I'm happy to do it both ways. I'm sorry, I can't see the chat for some reason right now. Okay, got it. If you want these questions to be answered right now, because they'll sort of put to rest all doubts. Yeah. These structures, I'm happy to do it now, or I'm happy to do it at the end, whatever works for you.
I think we can address few of these right now, just to cover whatever's been discussed so far.
Sure.
So the first question is from Ankur. He's asking, are there any different rules for advisors from outside India?
Yes, there are different rules for advisors from outside India. Shares for consideration other than cash. In fact, this presentation doesn't specifically deal with advisors from outside India, but the brief answer is that yes, there are very different rules for advisors from outside India. They cannot. It's very hard to issue them shares for consideration other than cash. It's very hard to give them phantom stock options. It's very hard to give them share warrants, because there are a lot of compliances involved. If there are, so the answer is yes. If you want specific details, I'm happy to take this offline and explain it in more detail.
Okay, sounds good. Then there's another question. Which is the most commonly used instrument for allocating equity?
Allocating equity, you mean when, for investors, or for, in terms of an advisor or a consultant, etc.? Because the answer is very different for both.
So in terms of advisors, let's discuss both if possible.
Got it. So for investors, you'll see that the most common forms of investment these days are three. You'll see a convertible note, you'll see an iSafe, and you will see a CCPS. Most investors don't like to invest through a plain vanilla equity, because there are a lot of problems there. The equity shareholders get paid out last in case of a dilution, in case of a dissolution, etc. So for investments, these are the three most common structures. There are obviously also very different hybrid structures which are going around now. One is share warrants, another is venture debt, and obviously it really depends on the needs of the startup and also what they're able to secure in terms of funding. Now, coming to advisors and consultants, etc. Currently, we're seeing that if you look at plain numbers, I'll say that till now the most commonly used structure has been Esop. Okay. But now we are seeing a marked shift to phantom stocks or to stock appreciation rights. I'll cover that in detail. That's the next part of my presentation. I will cover the features of that a little later.
Okay. Then there's another question from Ankur. What are some key terms to remember when giving a new person some equity?
Transfer restrictions. So it really depends on what the person is bringing and the role that the person is getting the equity in. Now, let's say that if that person is an advisor, then you will only want to limit their rights to economic benefits. You will not want to give rights like affirmative vote items or consent rights, information rights, specialized voting rights, or preference in liquidity, etc. To advisors or consultants. But if you're looking at an investor, then obviously the game is very different, right? Because the investors really dictate the terms. While you can push back on a lot of things, there are a standard set of terms that they'll require, like anti-dilution. They'll require affirmative vote items, etc. But the most important terms for advisors are what I mentioned, as well as a specific clause which says that you cannot transfer these shares without our consent, and that if your association ends in a manner which is not suitable for the company, or if it's an incoming founder that you're awarding, if their association ends or they refuse to provide the services, etc., and you've already given them shares by a transfer, then a clawback clause is something that we see very commonly, where the other founders have the right to take the shares back at their option if the new founder is not providing services effectively.
Okay, got it. I hope that answered your question, Ankur. Then we have another question which says, how can we calculate the equity to be given? The percentage, is there any fair way to calculate the percentage?
Yes. The percentage is obviously just a function of, let me preface this answer. The percentage that you'll be giving will obviously be the percentage at that time that you're giving equity on a fully diluted basis. Now, fully diluted basis means if you've already received investments or if you already have convertible instruments, you will consider those instruments to already have been converted, right? And then you will calculate the number of shares being given to this advisor or whoever you're giving it to. And that number of shares being given will be divided by the total number of shares of the company. And that will give you the percentage. What will happen is that this percentage will obviously get diluted in the future when when investors come in. Like all other shareholders, consultants, employees, etc. Everybody will get diluted in terms of absolute percentage when new investors come in.
Right.
In terms of tools, there are 2 tools out there that you can use. Obviously, you can reach out to your lawyers and to your CAs to help you with your cap table management. But if you want to do it on your own, there are 2 tools to do it. One is My Startup Equity. That's being done by Lex Venture, and the other is by AngelList. Both of these tools are not free to use, so you will have to pay for them, but they're very, very effective in terms of cap table management.
Okay. And so another, I think, aspect of the question is that, is there any way to calculate the percentage number, like the number of shares to allot to someone, especially when the services that they're giving are qualitative?
No, it's a purely commercial evaluation that the company does, and obviously the other person has to agree to the percentage. I will leave you here with the standard, the standard range that we deal with for advisors, consultants, employees, etc. The overall Esop pool will usually not be more than 10 to 15% of the company in an initial stage. The per employee percentage will usually not be more than 0.01% or 0.01% to 0.15% is what we'll see per employee. For advisors, we can see anywhere between 0.15 to 0.75 and 1%. But 1% is usually the upper number where, unless there is something like, a lot of funding that's been brought in by such an advisor, 1% is the upper limit to what we'll say that we'll give you. That's the standard range.
Okay. Got it. Then there's a question from Anil. Anil's asking, what is the usual exercise period from the time the options get vested?
The exercise period is a function of commercials. Usually we'll see 5 to 10 years as a standard. What happens is that if the employee hasn't exercised his shares at the end of the exercise period, then those exercised options, they sort of retire and they expire, and you can't. Then the employee can't go ahead and say that you have to give me these shares. But the standard answer is 5 to 10 years.
Okay, then another question from Ankur. Are the Esop advisory shareholders subject to dilution?
Yes. Everybody in the company is subject to dilution.
Another question, which is the best way with minimum compliances and cost to allot equity to a mentor?
Stock appreciation rates. It is not regulated at all for private limited companies in India. It's a purely contractual right, and the benefit for that is that there is no actual equity dilution. The mentor is getting, I'll explain it in detail when I come to that part of the presentation. The mentor will be getting the benefit from the stock, which is the liquidity and the appreciation in the value of the company, without actually holding any equity in the company. So that is usually acceptable to both the mentor as well as the company.
Okay. Question from Karthik. What are the limitations of giving equity to serviceable options?
The limitations here are, there's high compliance cost. A registered valuer report will cost you, depending on your relationship with the valuer, with a minimum of 15,000 rupees, and can go up to 50,000, 55,000, 60,000, depending on the value of the shares at that time. You can go even more. So you'll have to, for this option, you have to get two valuation reports. One is for the actual value of the shares that you're allotting, right? The second is for the actual value of the services that have been done. Now, over and above this, the additional compliance costs are in terms of secretarial costs, legal costs for drafting this agreement, making sure that everything is in order. So you will have to, then you will need to give them a tax opinion also, because most advisors will want you to tell them, how is this going to be taxed? What's the problem? And when this happens, usually the TDS has to be deducted by the company where they're giving these shares. And once that is deducted, it may or may not be recoverable from the mentor, depending on your relationship with them. So these are the limitations to why you wouldn't want to go for a serviceable option.
Got it. Hope that answered your question, Karthik. Then there are two more questions. One from Anil. In your experience, what is the practicality of performance liked Esops? Is that hard to articulate and monitor?
Performance-linked Esops are easy to monitor. As long as you make sure that at the time of drafting the policy, it's an objective criteria, right? You can't say you will get these Esops if you provide services satisfactorily to the company, because that is not an objective standard, and that becomes that much harder to defend for you if you're not giving them the Esops later on. What you can do is link it to specific KPIs, right? Let's say if it's for a salesperson, right? You'll say that, okay, you getting the Esops is dependent upon you hitting these targets in the first year, these targets in the second year, these targets in the third year, right? Similarly for advisors, if they're advising you in terms of increasing the valuation of the company, raising investments, etc., you can link it to saying you will get these Esops, depending on, obviously for these advisors, they have to be an employee or a director. So, if it's for a director, you will say that, okay, if we raise, $20 million in the next 2 years, then these Esops will vest, and then you'll get the benefit. So it really has to be a very objective standard. That's the answer. It's a very straight answer. As long as you can objectively write down what those criteria are, and you do that in the agreement with the employees for the Esops, as well as in the Esop policy, it is fairly easy to monitor and implement.
Got it. One last, can be another question now. So, question from Farmer007. What is the difference between shares and additional shares?
Sorry, shares and additional shares.
Yeah.
Additional shares are not something that we see very commonly. Additional shares, in fact, is not really a word that's used in the Companies Act. What you will be seeing is shares and securities. Now, shares and other securities will include your debentures, convertible debentures, non-convertible debentures, as well as share warrants, etc. The key the underlying difference here is that a share is obviously a unit of ownership in the company, whereas an additional share, or any of the other terms that I mentioned, any other security, is a right or interest in the actual ownership of a share instead of an actual share. But if you're referring to something specific and I've missed out, can we unmute them, and if you can explain this question better, that would be very helpful.
Srinivas, if you want to unmute and ask the question, you can do that.
Yeah, thank you, ma'am. Actually, sir, generally, everyone says that 4% share for the Supreme Incubator, we are going to allot it as additional. So it has taken from the main shares or from the outside the share.
Sorry, can you repeat that?
I think his question is about fresh issue.
Okay, you mean so you mean like a
secondary?
Yeah. So you mean a secondary transfer or a bonus shares issuance, or a rights issue later on, etc. So an additional share will be basically shares. It really depends on how your agreement is structured, but it's effectively any share. Some part of the shares that are issued in the future by the company. So let's say your current shareholding structure is you have 10,000 shares of 10 rupees each, not counting the share premium, and at a later stage your paid up shares increase. And let's say somebody has a right in 4% or 3% or 2% of the shares, then they have the right to subscribe to these shares or be allotted those shares. Now, what that will usually be done is, because usually for an incubator, it is usually shares for consideration other than cash, because they are providing you incubation services, right? That's their value add. So that's the difference between a share and an additional share. It's the right to acquire shares at a later date when the company is going for a finance round next time. Does that answer your question, Srinivas?
Thank you, sir.
Yeah. Please, no need to call me sir. My name's Akshit. We all work on a first name basis. I believe Yogita had raised her hand in the middle. I don't know. So I don't know if she wanted to ask a question or whether that was accidental.
Yogita. Yeah, maybe Yogita, in case you have a question, you can write in the chat and then we can address it and you can unmute if needed. Another question from Anil: for a startup, what in your experience is the breakup between cash and non-cash compensation for founders and key employees?
For founders, we don't usually see non-cash compensation options that much because the founders, by nature of them having started the company and incorporated the company, will already own a substantial part of the equity of the company. Now, if it's an incoming founder, we'll usually see it's at a very early stage. We'll see a split which is more heavily inclined towards equity than to cash. That's simply because the startup is unlikely to have enough cash to pay their key employees or their incoming founders.
Right.
The
So I
split
think
would be 70-30, 80-20. It really depends on the amount of cash that the company has and is willing to spend on salary at that time.
Yeah, hope that answers your question, Anil. If you have a follow-up, you can unmute. Okay. Then there's another question from Srinivas. Must there be a 51% stake in the company in the name of the founder?
No. Let me answer that actually I'll explain why I said that. The reason behind why you want a 51% share in the company is because you want to be able to take decisions for the company, right? Usually if it's more than one founder, which is usually, which is likely the case, then as long as you hold above 51%, it's fine. However, even if you fall below 51%, right, you can say that you can give differential voting rights to the shares held by the founders and say that, okay, these 30% of the shares that are still held by the founders will have voting rights equal to 60% of the company. And that is something that's legal and is permissible by law. I hope that answers your question.
If you have any follow-up, Srinivas, you can unmute.
Sir, actually, sir, 51% is compared to the other shareholders. I am the March shareholder, maximum shareholder. The same way, if you have 3-4 members, 30-30 like that, if I have the 40% plus, then I will be the decision maker. Like that, it is possible?
Yes and no. Yes, you will be the decision maker. However, when you go for an investment, you will be giving up a lot of consent rights to investors. So you will not be able to take certain decisions without the consent of the investor. So even if you hold 51% or 60% or 70%, depending on the consent rights that you've given to the investors, you will still not be able to do certain things with the company, such as sell off all its material assets or take a lot of debt, etc. All of these things are things that you'll get consent rights for. Does that answer? Was that the question?
Yeah, of course. Actually, sir, my intention is that generally this is not a colorful journey. There is a lot of up and downs. According to until we get some minimum revenue point, we have to go through so many challenges. That time we have to take so many dare and dash decisions. That time, every time we have to interact with the investor or this kind of negotiation will be there. So that's the reason why generally the angel investors are some other investors maybe restrict our process or making decisions like that. They have some powers or not.
Yeah, so they definitely have the powers, but at the same time, investors, why are they investing, right? They want higher returns. So if they trust your abilities to execute, they will not stop you from taking decisions which you should be able to take. Similarly, at the time of signing the investment agreement, you have to be very careful in terms of the consent rights that you're giving to them, right? Also, there are a lot of things that you can do without being 51% shareholders, and just by virtue of being an executive director on the board. So not everything that you want to do with the company requires you to be a shareholder. A lot of acts, a lot of most operational decisions can be taken by a majority of the board directors. Now, let's say you have 3 directors, 2 of which are the founders and 1 is the investor. As long as that is a purely operational decision, the founders are free to take it, and there'll be no latency between them having to take the decision and them actually taking the decision.
Thank you, sir. Actually, sir, my main term, I always fear with these terms and conditions, sir, because they use this high-level languages, sir, so low-level language. Everyone has a different of logics they play while writing the terms and condition. As a founders, we don't aware of that because we are fully concentrating on the problem and solution, and we have to go through so many different of solution stages. So every time these terms and condition, not only the shares, not on the while interacting with the CS or some other patent rights, every time this is a big. We are not afraid about the problem and the solution. Always these terms and conditions, because everyone have a great experience. People are there. Some investors will write terms and conditions with the great people. We can't track that terms and condition. So how it is possible for this make this successful journey? I think this is a very clumsy word for us, sir. To be frankly, I'm saying. So last time also I requested Tanvi ma'am. So please engage like your professionals, because we don't want to deep into this. Because if you, madam, suggest anyone one of your like team like you, just we will sign up with you, because this part is a depth, it's an ocean. We are not into deep in that. So if we type with you, you will read all the terms and conditions and what are the loopholes. You can easily find out. It is to be frank, I'm saying no founder is an expert in that sector. To be frank, everything goes in properly, everything will be happy. But sometimes it is not in our hands. Something goes wrong. We are unable to handle that worst situation. Same time, we have to unable to control this kind of people. Right. So yeah, so I'm sincerely requesting. Maybe I'm wrong. Please correct me. Thank you.
Absolutely. See, that's the benefit of having a good legal counsel, right? A good legal counsel, especially a specific lawyer who deals with startups. What they'll do is, when you are looking at these terms and conditions, they will do the drafts. They will review the drafts. Then what I do is I will write it down in very, very simple language for you to explain to you, what you are really agreeing to. Because as you said, these contracts are written, whether deliberately or not, by investors in very, very, highly specialized legalese. So you may not be able to decipher what they really want to do. So a good lawyer will always write down a structure note for you, or a simple pros and cons for you, or just a very simple note explaining what the agreement says, and then you can go ahead and sign it. Or we'll take you through it clause to clause and explain it in simple English. Now, the way that this is straying off the topic from the current presentation, but the way that we draft contracts here at my firm is that we use simple English. Like we've drafted audio contracts for farmers. We've drafted contracts in 3, 4 pages. We draft very simply so that everybody who reads the contract should be able to understand what it says, right? The idea is not that everybody who's reading the contract has to then go ahead to a lawyer. The idea is that the person who is signing the contract, whether it's your customer or whether it's you, should be able to understand what the contract says. And we can take this discussion offline in terms of how best we can help you here. But the short answer is that you should definitely engage legal counsel when you are dealing with highly specialized contracts, because as you said, you will not be able to do it on your own.
Thank you, Ji. Thank you, Goyal Ji.
So we have 2 hand raises also. Gaurav, any particular question in mind? Yeah.
Hi, Akshit.
Hi.
Yes. So I want to ask that what would be a fair vesting period and a cliff? So usually 12 months of cliff, is a fair cliff. But when it comes for vesting, share vesting period, that after the 12 months of cliff, would the shares be vested annually, quarterly or monthly?
It depends on what you want to do. If you want to do it monthly 1%, you can do it monthly 1% over 100 months. If you want to do it 10% every year, you can do that. If you want to do it 5% every quarter, you can do that. It really just depends on what you want to do. If you want to do it in any way, it can be done.
All right. So it's up to the founders, and I mean, as per the mutual agreement. So
yeah, usually ESOP policies are not mutual agreements. ESOP policies are usually a leave it or take it, right, for employees, because they don't have the leeway to really negotiate. Because how an ESOP policy will function is that you will first pass a board resolution approving it, then you'll have a special resolution from the shareholders approving it, and then you'll make it an ESOP policy. And all of these terms, the vesting period, etc., are all decided by the company. So usually it's not by mutual agreement. Obviously, you have to make sure the terms are something which are fair, so that people are actually incentivized by it. But it's at the end of the day, it's a commercial decision by the company.
All right. So one small thing I want to ask, I mean, if the shares are vesting monthly or quarterly, so the vesting period, I mean, if considering 4 years, would be remaining the same. So it won't be increased or decreased based upon, I mean, vesting it monthly or quarterly.
No. So what happens is that vesting period and vesting is the same thing, right? So if your shares are vesting in a quarterly fashion, then usually those shares which have been vested can be exercised at that time. Even if your longer vesting period runs for 4 years or 5 years, if 10% of your shares are vested in the first year, you can then exercise that option for those 10% of the vested shares.
All right.
But if you want to specifically restrict it, you can do it in the ESOP policy, but we don't see the structure happen that commonly. Is there a specific reason why you want to do this?
So I'm just asking, I mean, usually what is the fair, I mean, vesting period? I mean, vesting it after 12 months. So quarterly would be a fair first.
Yeah. So the minimum is the 1 year cliff is definitely there. After that, what we usually see, and the most common structure that we see, is 3 or 4 years, and then 25% or 30% or 33% of the shares vesting over each year. That's the usual structure.
All right. After every 12 months.
Yeah. So after every 12 months, 25% shares will vest.
And if a person is taking an exit, let's say after 1.5 years, after 1.5 years, so the person can claim only the shares that is issued under his or her name.
Yeah.
I mean, that was at 12 months.
Can only then claim the shares vested for the first year.
Yes.
They can't claim the shares vested. They can't say, okay, I worked for 6 months, so 12.5% also I'll get. That's not something that they can.
The same agreement that we are following, that is for every 12 months, 12, 30, I mean, 12, 24, 36, 48.
Yeah.
Right.
Yeah.
Thank you so much.
How you do it. But if the employee is exiting, you can, there are enough companies which say that you can't exercise these options. First, obviously, they can't transfer these options or these shares. The second is that they'll allow you to limit their employment, right? So if they exit after 15 months, you can say that you won't get any of the shares that you've that are vested, but you haven't exercised already.
Mm-hmm.
So you can write that in the contract, and that's fine.
All right. So I guess, I mean, we are doing a fair practice. I mean, we are doing a fair agreement for everyone. Thank you so much.
Thanks, Gaurav. Jyoti, you had raised your hand. Do you have a question? Okay, Jyoti is not on the call right now. Okay, Akshit, I think we can continue if it's okay with you. If you want, you can take a break as well. It's been,
that's fine.
talking for so long.
Like there will be more questions in the next two structures. So let's go through them, and then we'll do the question answers for that.
Yeah.
So the next, as I said, this is phantom stock, which is what we usually call in legal language stock appreciation rights. They're called phantom stocks, promoters, phantom option plan. You can call them whatever. These are not regulated in India, in the sense that obviously there are limitations to what a contract can do, but these are a purely contractual right. This is not regulated by the Companies Act. There is very little compliance that you have to do. Therefore, this is a very attractive option that we are seeing being adopted increasingly now. The features are that this is not an actual right in the shares of the company. There is no equity dilution. This is a purely contractual right, which is pegged to the value of the shares underlying the contract. It's a derivative instrument. What happens is that, let's say I am an employee and you are the company. You are giving me 100 stock appreciation rights. What that will do is each SAR will be linked to, let's say, one equity share. the fair market value of the equity share at the time of issuing of this stock appreciation right is, let's say, 10 rupees, which is at the initial stage. Later in 6 years or in 5 years or in 3 years, whatever, it increases to 20,000 rupees per share in terms of fair value. Then what you will do is the appreciation, that is 20,000 minus 10 rupees, is the monetary benefit that has to be given to this SAR holder. There is no equity dilution. They never get the shares. What they do get is the benefit that they can get from the shares. And why do we want shares? We want shares because we can then sell them off at a very high valuation and gain money from it. So this effectively bypasses those steps and only gives the person a cash payout at the time of exercise. Now this exercise can be this time of exercise. There is a cash payout that is done by the company. It can be quite high depending on when the stock appreciation right is exercised, how many stocks it sort of applies to, etc. But usually these exercises are linked to investment rounds, etc. coming in. What will also happen a lot of times is that investors will say, okay, let's finish it off right now at the previous valuation before we put in our money, so that we don't have to then pay them out at a much higher valuation later. So these are effectively, this is what an overview of what a stock appreciation right is. The benefits, as you can see on the screen also, they're very easy to monetize because it's a pure cash payout. There are transferable contracts. You can say that, okay, these SARs I am transferring from I'm transferring it from myself to my friend, and I will take money from my friend at this time, depending on the commercial agreement between me and my friend. And the friend can then exercise it at a later date, depending on whenever they want to do it. Right. As I said, this is not regulated, so there is very little compliance for a phantom stock option. There are no disclosures which have to be made to SAR holders. Now, for Esops, for sweat equity, shares that issued for consideration other than cash, there are certain disclosures and information that you have to give them from time to time, like the balance sheet of the company, etc., etc. You have to tell them this is what the companies, etc., is doing. For a SAR holder, you can be completely opaque. There is no, you don't have to disclose information that you don't want to. The final benefit is, as I said, there is no cash payout by the beneficiary and no equity dilution. The disadvantage is, as I said, the company may have to incur a significant cash flow crunch at the time of exercisation of SARs, depending on how many SARs they've given. And SARs the holders may want to cash out, at a time when the liquidity has a problem. You may have seen, let's say at the start of the COVID crisis, some SAR holders may have wanted to cash out because they didn't have the liquidity. You can protect yourself against this by simply writing into the contract when these shares can be, or when this SAR can be exercised. I'll move to the final structure now, which is a share warrant. This is the least commonly done structure in India, and I believe not because it's not beneficial. It is only because of the very little knowledge that's there prevalent around this structure. A share warrant, as I touched upon in my answer also previously, is nothing but a right to subscribe to shares of the company in the future at the value that you agree to now. So I can say that I have the right to acquire, to subscribe to 500 equity shares anytime in the next 3 years, but I will pay you 100 rupees per share, which is the fair market value right now, or 80 rupees per share, which is less than the fair market value right now. Right? What that does is it allows for people to give you some sort of nominal face value, and then for them to acquire the shares at a later stage. It's very similar to what a convertible note does, but this is not usually something we see as an investment instrument in India because it's not that common. The benefits are the share warrants are transferable. It's a contract that you can transfer to others. They can be performance linked. You can say that you will only get them depending upon, you will only be able to exercise the share warrant and subscribe to those shares at this value depending upon ABCD conditions that you fulfill. And the next is no significant cash payout by the beneficiaries. The share warrant is usually at a nominal or very, very early stage value. So these are the benefits. The disadvantages, again, like all other instruments except in SAR, there is obviously equity dilution. The price received by the company at a later date may not be acceptable. Let's take an example where I have SAR, where I have a share warrant to subscribe to 100 shares later at a date of 10 rupees per share. That's 1,000 rupees of outflow for me. At a later stage, the company is now valued where each share of the company is worth 1 lakh rupees. Right? So now I'm giving 1 crores worth of share only for 1,000 rupees in return. So, this is something that has to be taken care of by the company in terms of how best to structure it. It can be a variable conversion also. You can convert the share warrant saying, okay, we won't agree to the value right now. We'll say that you'll get it at a 20% discount or a 30% discount to the fair market value at that stage. That is also something that you can do. Finally, as I said, because it is the least common structures in India, they may not be acceptable to either your investors or to your advisors or to your employees, simply because they may not have done it before. I believe that's the end of my explanation. The final thing, as I said, I haven't included in this presentation, is a plain vanilla transfer by the founders. The only time that makes sense is when a new founder is coming in at a very early stage where there's been no investment of the company, and you can transfer the shares at a nominal face value. However, the problem with that is if you transfer these shares later, the founder says that, I don't want to continue. How do you get these shares back? So while you can do clawbacks and power of attorneys, etc., it is always advisable to not give actual vested physical shares to anybody at an early stage who's getting the shares depending upon their performance. So that's it from me on all these structures. Now, I'm sure that there are questions. Let's sort of go ahead with the questions.
Yes, thank you so much, Akshit. I think the last two are also quite interesting, and I personally also didn't know a lot about share warrants, so really helped to hear your explanation. Now there's another question from Nitin, who's asking, how are share appreciation rights taxed, from the perspective of income tax? What is their taxability?
They are only taxed once. They are taxed as because effectively they're a cash bonus by the company. They are treated as perquisites and taxed as professional income. So they will be it depends on the income tax slab rate of the person who is receiving the benefit. For the company, the only implication is that they have to withhold taxes at the rate of 10% usually when they're making this payout. And then they have to report it at the end, and that's it. For the company, there is no tax. There's no tax implication. For the people who are receiving the benefit, also it is lower depending on the slab rate as compared to an ESOP. An ESOP has double tax incidence. This only has one.
Okay, hope that answered your question, Nitin. There's another question from Shubham who's asking, do we have dual class share structures in India?
Nitin, can you unmute yourself and explain? Because because there are multiple ways in which I can interpret this question. You can either, you can mean a CCPS, you can mean an equity share, you can mean differential voting rights. So I'd like to understand what you mean, and then I can answer the question.
Shubham, can you unmute?
Yeah, hi. So Google founders, they have a dual class voting structure, right? So they own 11% of the Google and they control more than 50% of the Google voting rights. So in that sense.
Yeah, absolutely. So what you're referring to is what we call differential voting rights. Differential voting rights are absolutely permitted. They are permitted at two levels. In fact, one is related to your shares, which allows you to, let's say you hold 10% after a Series D or a Series E, or that I'm going public, but you still want to take decisions for the company. Then, depending on your differential voting rights, you can even hold 51% of the share, the overall voting power. The second is not strictly what you're talking about. It is that we can contractually give one director or two director or a chairman of the board to an additional vote. Let's say the board is now 5 people, but you and there's only one other founder, so that's 2 against 3 investors. Then in that case, you can say that the founder can have a casting vote or a second vote, and allows you to sort of take decisions for the board also. So there are 2 ways that you can do it. And both are completely legal in India, both are recognized. The second is very uncommon and is a very new structure that we've been playing around with for a couple of our later stage investments. And most VCs are not comfortable with it and don't allow you to do it, but it's something that is being done. The former, the DVRs are very common, and they can be seen in a lot of investment transactions at a later stage.
Any follow-up, Shubham? Hope that answered your question.
No, thanks.
Okay. Srinivas is asking for contact details. So we can connect you over email, or if you want, you can share here, whatever works for you.
Let me just go back to the first screen and you can have the contact details. If you could also connect me over an email, that would be very helpful.
We'll do that.
So these are the contact details. We are, as I said, a full service firm. Our corporate office is based in Defense Colony. We have a team of 12 associates just for the corporate practice. And we're happy to help you with whatever you need. So you can reach out to me directly at Akshit@jkgalawchambers.com, or that's my work number. You can drop me a line. Feel free to call me.
Okay. Thanks, Akshit. One last question from Ankur. Can we make a secondary transfer to advisor joining right after inception?
Yes, absolutely. That's what I explained at the end, for which there was no slide. That is a plain vanilla transfer by the founders. That is absolutely doable. Though there are a couple of things to keep in mind there. The first is the commercial implications. The reason you want to give them is because advisors will give you some benefit at a later date, and you want them to realize that benefit. But in case they don't perform up to the mark, or you don't like the advice, or there's a rift later on, getting those shares back from the advisor can be very problematic. So how it's usually done is that you will enter into a share purchase agreement. You will say that, okay, we will give these shares to you. These shares will be held in escrow, and the share certificates for this will be held by somebody else. And you will be given these shares at a date at 2 years, 3 years, or depending on certain fulfillments. And if you leave the company, or if you don't provide the company, then we have the right to transfer these shares back to us. That's how it's usually done. Now, there's also a tax implication on this. If it's at a very early stage, right out of inception, there is no problem. But if it's after, let's say you've already raised a round, then the problem that happens is that even if you transfer it at face value, which is 10 rupees per share or 100 rupees per share, they will have to pay income tax at which is the difference between the fair market value and the transfer value of the shares.
Okay. Hope that answered your question, Ankur. Oh, there's another one from Ankur. Under stock appreciation rights, what can be a potential drawback for the beneficiary?
Potential drawback for the beneficiary will be that they don't have any rights over what the company is doing. They don't have any transparency. They don't have any visibility. That's the correct word. They don't have any visibility into the affairs of the company, because there are no mandatory disclosures that have to be made to somebody who holds a stock appreciation right. Another thing is that depending on the way that the contract is structured, when and how you can exercise a SAR can be very limited.
Yeah. Got it. I think those are all the questions. Any follow-up questions? If anybody has any questions, please feel free to unmute or ask in the chat. Anything related to what we've discussed today?
Even if it's not related to this and you want general other questions, that I believe we have 15-20 minutes left for the session. It was supposed to be 6 to 7:30. Depending on if you guys are okay. If they have any other questions on whatever they're doing, whether on tech, whether on specifically this or other legal advice, I'm happy to answer those also.
Hi Akshit, Abhinesh this side. I have one question related to like founder agreement and like what happens when a founder moves out or a new founder join in. So there we came across, like, we had session regarding a founders agreement with like co-founder agreement that happens. So does that cover the clause when like one co-founder leaves, what happens to his part of the ownership, or is there a separate agreement that needs to be done for that?
No. So your a well-drafted co-founders agreement will always cover that. Well-drafted co-founders agreement will have I'll list out very key clauses. The first is restriction on transfer by the founders. No transfer will be able to transfer no founder will be able to transfer their shares without the consent of all other founders. That's one. The second is for incoming founders, how will they be rewarded? Whether it will be a transfer from the existing founders, whether it will be an SAR, whether it will be an Esop, all of that will be included. The third will be capital contribution by the founders. Who's going to bring in how much money, whether it will be a loan, whether it will be fresh equity infusion, etc. Then another is what happens at the time of exit. Now this will be covered in the founders agreement, but there are multiple ways to do it. You can you can just say that the shares of each founder will vest over a period of time, similar to an Esop. And these are restricted shares till the time that they vest. And if the founder is either resigning from the company as an employee or resigning from the company as a director, then all of these shares will be transferred back to the other founders, depending on whether they've vested or not. Usually what happens is we call this an escrow structure, and then we take a power of attorney from all founders in favor of the other founders, allowing them specifically only to transfer these shares back to the other founders. Does that answer the question?
Yeah. So actually, I came across a term while I was going through these. There was a separation agreement. That's why I wanted to ask whether like separation agreement is separate or it is part of the founders agreement.
So a separation agreement is effectively the agreement that you will sign after, when the founder is already exiting. So it will be different. However, what the terms for how these founders will be exiting and the terms for how the shares will be transferred, etc., will be in the founders agreement. Then to actually give effect to these terms at the time of transfer, this separation agreement or this exit agreement will be signed, which will depending on whether it's whether the exit is acrimonious or not. If it's a very amicable exit, then they'll just transfer the shares back to you, or it'll be by the POA, they'll transfer the shares back, and this exit agreement will be saying things like you don't have any claims against the company at the time of exit, there are no dues to be paid, you don't have any ownership of the shares, etc. So it is a separate agreement, but the key terms will flow from the founders agreement.
Okay, yeah, thanks. That clarifies.
The floor is open if we have any more questions.
Ma'am, this is from Thomas 007. Hello, sir. Hello?
Yeah, you're audible.
Yes. Hello.
Yeah, actually, sir, this is a simple and silly one, maybe, because this is a digital platform. So software won't cooperate in India. But actually, sir, my intention is that generally copyrights or whatever the trademarks, whatever it happens, once we get succeeded only, then the other competitor or other patent holder will put the case on us, right? Then generally we get good revenue only. If we get some success only, others will do some legal complaints. If we fail, there is no chance like that, right?
Yeah. So the risk is actually very limited if it's if it's something which most companies do, as long as it's just a platform providing services, as long as what you're doing is not really patentable. The only protection that you have is your market reputation, your trademark, etc., and making sure that other people can't use your trademark. The corollary is that you cannot use the trademark. Let's say you're farmer 007, right? So I'm assuming it's something agri-tech. Now you can't use the trademark of any other agri-tech company, but by virtue of the services that you provide, it's very unlikely that they will have a legitimate patent claim against them. So as long as you don't do anything wrong and you don't infringe their IP rights in terms of trademark, etc., it's very hard to go ahead and show that you owe them damages or you have to pay them some compensation.
Of course, we are maximum trying to our level best, but this is a fuse. It's a big. It has so many layers in this sector, so we have to cross all the layers. So sometimes maybe, may not be. So we are feeling that actually, what is the legal issues? Only they will charge the money as a fine, or some other issues.
Sorry, can you repeat that? I lost the last line.
If we break some rules or if we violate the rule, if we use the other trademarks like that, what is the punishable? It is in the matter of only money, or they will do some other.
There'll be, so I'll answer the question specifically for trademark. For trademark, they will file a suit for you for two things. One is for damages and for loss of profits for them, right, which will be a monetary suit. The second is an action asking you to stop using that trademark or to change your trademark if it's very similar. So this happened in the case of Starbucks versus Sardarji Baksh, which is, as it's now known, the coffee company. And what Starbucks did is that they thought that Starbucks, this new company, was trying to earn profits out of their own brand name, and therefore they filed an action for passing off and said that you can't use this trademark. So in this case, there was no compensation for money, but only restricting this new coffee company from using the trademark similar to Starbucks.
But because I'm asking like this, because iPhone versus Samsung, it has taken so many years to finalize the case. In that scenario, of course, it takes some time. Of course, if anybody comes like that, we will negotiate and maximum will try to go in a friendly manner. But all times it may not be possible. So same time in my sector in architect, so many layers is there, so many different companies are different sectors they are using. So they may not be. Sometimes we may get violated. So that's the reason only I raised this question. Thank you for your clarification, sir.
No problem.
Sir, generally you sorry to interrupt you. Sir, you will give the services for the trademark also?
Yes, we're a full service firm. We do, you think of a legal problem, we can help you with it. It's tax, IP, disputes, obviously corporate startups.
So generally my startup name is farmer007.com. That name itself, it shall be, I want to make as a trademark. It is possible?
There are two ways to register a trademark. One is a logo mark, which is, let's say you can see my logo on the screen, right? It's JKGA.
Yes.
I register this logo, and what I'm registering only is preventing people from using JKGA in this formulation. That's the first one. That's called a logo mark. The second is a word mark, which is what you're talking about, which is Farmer007. If you register that as a trademark, then nobody else can use Farmer007 in any formulation whatsoever. Now, the problem with going for a word mark directly is that there's a higher threshold for a word mark registration. You have to show that it's unique, it doesn't infringe on anybody else's trademark, etc., and that there is enough to it's not a generic description of what you're doing. You can't just say farmer tech and ask for it to be word mark. But Farmer007 is something that I think it can be word mark, but it's a decision that has to be taken on a case-to-case basis. We usually advise companies, unless the name is very, very different, we advise them to first take a logo mark registration. What that does is that it stops anybody else from using that name in that formulation. And then another 6 months or 8 months or a year, then we go for a word mark registration saying that, listen, we have already been using this name and we have a registered logo mark. Please give us a word mark also. And then we see that word marks are granted generally easier if you already have a logo mark in place.
So actually, the domain is purchased by ourselves. So that domain also comes under the word trademark. It has to be.
No. So if your website is farmer007.com, somebody can come ahead and buy a domain farmer007.in as long as it's available online. What they won't be able to do, however, is put your logo and put your name on the actual web page when somebody opens that if you have a trademark. The domain itself is not trademarked.
Okay. Actually, sir, in your logo, there is a black, it is in the color mode. Generally, one person told me that we have to submit the black and white logo further apply trademark.
No.
The colors also is the considerable.
Yeah. So if you're going for it depends. If you're going for a word mark, as I said, if it's just the words that you're registering, then black and white color doesn't matter because the only protection that you will get is a wider protection. So the entire words in your logo. But if you're going for a logo mark, then it's the exact way your logo looks.
Okay, sir. Actually, this is not the open question. May not be because generally I have two words, sir. Farmer007, Indian007. For both word marks, what the charges from you? Actually, it is not. I have to ask it in the open. There is a minimum charges for that.
Offline.
Yeah.
Okay. I will go to the offline. Thank you.
I'll leave you here, on this question by saying that because we have a dedicated startup practice, our rates for startups are heavily discounted. We work on different sorts of compensation models depending on what the startup is comfortable with. So we can get it done for you at a very competitive price. But the cost itself will depend on the work. Let's take that offline.
Okay, thank you, Goyalji.
Okay, we can conclude the session here. Thank you, Akshit, for this very detailed session. It was very helpful. We look forward to more such
Absolutely.
interactions.
Thank you so much
future.
for having me, Darshana. It was a great pleasure speaking to all of you. And I would have loved to hear a little bit more about what everybody here is doing. But I'm sure that conversation will be set up at a later time. As always, I'm free to chat on all things tech, law, and whatever you need help with, whether it's with investments or with actual legal work, please feel free to reach out. I'm sure Darshana will put you in touch if there are any questions.
Definitely, we'll get in touch with you in the future. Thank you.
Thank you.
Thank you,
Darshana.
everyone.
Thank you. Thank you so much, Akshit. And with respect to what you said, we're more than happy to host, casual meetup with all the founders with you if you'd like to chat about what everybody is doing and share your feedback, insights.
Absolutely. I would love that. I think it's always good to know what's going on in the market, because there are a lot of times when, I may just have, for example, I may be able to connect you with specific people, which may be your target audience also. So let's schedule that. Let's take that conversation off.
Absolutely. Absolutely. Thank you so much.
Thank you. Okay.
A small feedback on the session. All the sessions are very good, sir, in the previous sessions. But your smile face is from the beginning to end, you are continuing in a good manner, sir. And you are given a maximum time for the participants. Generally, we won't get this much time in the last sessions. Anyway, thank you to Tanvi ma'am and Goyalji. Thank you.
Thank you very much. The idea here is to answer your questions, right? You can find the information that if you do look hard enough, you can find the information that I presented on the slide on the internet. But the idea is if you have specific questions, then those need to be answered.
Absolutely. Thank you, Akshit. Thank you for joining. Let's, schedule a meetup soon.
Absolutely. All right. Thank you.
Thank you. Thanks, everyone.